Krajišnik submits that the trial chamber did not consider the general practice of sentencing in the former Yugoslavia. Erred by not analyze the gravity of the crimes and the aggravating circumstances separately, and impose a penalty that seemed to be a reprisal. The appeal chamber recalls that reference to the general practice regarding prison sentences in the courts of the former Yugoslavia is not binding. In the instant case, the trial chamber complied with its obligation to consider this issue. This argument is thus rejected. With regard to Krajišnik's argument that the trial chamber failed to assess the gravity of the crimes and the aggravating circumstances separately, the appeal chamber notes that the trial chamber indeed distinguished between aggravating circumstances on the one hand and the gravity of the crimes on the other, albeit considering them under the same heading. This argument is therefore rejected. Krajišnik further contends that the trial chamber should have considered his efforts and his involvement in peace negotiations, as well as the fact that he acted within his legal authority in mitigation of his sentence. However, Krajišnik fails to demonstrate that these factors would have been accorded sufficient weight to have any impact on the sentence, especially considering the fact that the trial chamber granted only very limited weight in mitigation to the factors explicitly considered. Therefore, this challenge is also rejected, and Krajišnik's appeal with respect to the sentence is dismissed in its entirety. The prosecution raises a single ground of appeal, arguing that a life sentence is the only sentence proportionate to the overall magnitude of Krajišnik's crimes. The prosecution does not point, however, to any element which would have been omitted by the trial chamber in determining the sentence. It merely argues that the sentence does not properly reflect the gravity of Krajišnik's criminal conduct and fails to ensure sufficient retribution and deterrence. The appeal chamber cannot conclude that the sentence imposed completely fails to reflect the seriousness of Krajišnik's criminal conduct, or that it does not express the outrage of the international community, and that it is grossly insufficient to ensure deterrent. The prosecution's first subground is therefore dismissed. Next, the prosecution argues that no mitigating factors justified the imposition of anything less than life imprisonment. The appeal chamber notes that the trial chamber found that while factors by themselves did not constitute mitigating circumstances, taken together, these factors amounted to personal circumstances of a kind which may be accorded some, although very limited, weight in mitigation. The appeal chamber is puzzled by this finding. A factor is either a mitigating circumstance or it is not. If it is not, it cannot be taken in mitigation, even when considered with other factors which do not constitute mitigating circumstances. The trial chamber should have specified which elements constituted, in its view, mitigating circumstances. Nevertheless, even if the appeal chamber were to find that the trial chamber erred in retaining some of the above-mentioned factors in mitigation, it would still not be clear that such error had any impact on the sentence imposed, as the trial chamber itself stated that it accorded very limited weight in mitigation to these factors. Thus, the appeal chamber cannot conclude that the prosecution has demonstrated an error which invalidates the decision on the sentence. The prosecution's ground of appeal on sentencing is thus dismissed in its entirety. In conclusion, the appeal chamber has dismissed the prosecution's appeal and has granted amicus curiae and Krajišnik's appeals in part. While Krajišnik's convictions for 3 counts of the indictment that is, deportation, forcible transfer, and persecution based on these crimes, remain intact, the trial chamber erroneously imputed criminal liability to Krajišnik for 2 other counts, and most of the crimes mentioned in parts 4 and 5 of the trial judgment. The appeal chamber recalls that in some cases, the circumstances have warranted it to ascertain itself whether the trial chamber's finding on their own or in combination with relevant evidence sustain the conviction. Given the factually complex circumstances of the case, an appellate assessment of the crimes for which the trial chamber erroneously imputed criminal liability to Krajišnik would require the appeal chamber to re-evaluate the entire trial record. However, an appeal is not a trial de novo, and the appeal chamber cannot be expected to act as a primary trier of fact, as it is not, as a general rule, in the best position to assess the reliability and credibility of the evidence. Why Rule 117C of the rules vests the appeal chamber with discretion to order a retrial in appropriate circumstances, the appeal chamber is not obliged, having identified an error, to remit the case for retrial. An order for retrial is an exceptional measure to which a resort must necessarily be limited. The appeal chamber notes that the convictions for the majority of the crimes of which Krajišnik had been found guilty have been quashed. However, convictions for persecution, deportation, and forcible transfer have been upheld, and the gravity of these crimes requires a severe and proportionate sentence. Therefore, in the circumstances of the particular case, the appeal chamber considers that it is not in the interest of justice to remit the case for further proceedings. As a result, the appeal chamber has determined the adequate sentence for the crimes which were correctly imputed to Krajišnik. I will now read out the disposition of the appeal judgment. Mr. Krajišnik, will you please rise? Here's the disposition. For the foregoing reasons, the appeals chamber, pursuant to Article 25 of the statute and Rules 117 and 118 of the rules, noting the respective written submissions of the parties and the arguments they presented at the appeal hearing on 20 August 2008, sitting in open session, grants subground 3A submitted by amicus curiae, grants in part subgrounds 3B, 3E, 3G, and grounds 4 and 7 submitted by the amicus curiae. Dismisses, Judge Gunay dissenting in relation to ground 10, the remainder of the grounds of appeal submitted by amicus curiae. Grants the third ground of appeal of the Dershowitz brief in part. Dismisses the remainder of Krajišnik's appeal. Reverses Krajišnik's convictions under counts 4 and 5. Reverses Krajišnik's convictions under counts 3, 7, and 8 in part. Dismisses the prosecution's ground of appeal related to the sentence. Sentences Krajišnik to 20 years imprisonment to run as of this day, subject to credit being given under Rule 101C and Rule 107 of the rules for the period that Krajišnik has already spent in detention since his arrest on 3 April 2000. Orders, in accordance with Rule 103C and Rule 107 of the rules, that Momčilo Krajišnik is to remain in the custody of the tribunal pending the finalization of arrangements for his transfer to a state where his sentence will be served. Judge Mohamed Shahabuddin appends a separate opinion. Mr. Krajišnik, you may now sit down. Mr. Registrar, would you please distribute copies of the appeal judgment to the parties and the amicus curiae? Okay. Thank you very much. This concludes the appellate proceedings in this case. The appeal chamber will now rise.
All rise for your evaluation.